You all for this breakfast meeting on subject Prevention of Money Laundering Act, and to dwell upon this subject we have CA Bharath Lakshminarayana sir. Can I request CA Jaikumar sir to escort the speaker on to dais and then welcome him with floor voting. Thank you, sir. I have the privilege in introducing the speaker. Bharath Lakshminarayana is associated with Singhvi Dev and Munni LLP, Bangalore. He has over 17 years of experience in the field of taxation. He focuses on advising clients on Indian domestic tax and cross-border tax issues, tax optimization strategies, transfer pricing, and exchange control matters. He also regularly attends to matters involving representation before the tax authorities and income tax appellate tribunal. He is also presently a co-convener of Bangalore Study Group of the Chamber of Tax Consultants, Mumbai, and a member of the Executive Committee of the Bangalore ITAT Bar Association. He has spoken at Bangalore Study Circle of ICAI on topics related to income tax, transfer pricing, exchange control, and money laundering. He is a Bachelor of Commerce from Bangalore University. He is Associate Company Secretary from ICSI, and he is a Bachelor of Law also from Karnataka State Law University. With this brief introduction, I present before you Bharath Lakshminarayana. Over to you.
Good morning, honorable all. Am I audible?
Yes.
I just get a column. It'll be easier. Good morning, all. Thank you, ICI Bangalore branch, as always, for giving me an opportunity to share my thoughts on an emerging and controversial topic of money laundering and its impact on chartered accountants. It's Saturday morning, pre-Deepavali. So one of the first questions which I asked the organizers was, are there going to be people for such a great topic? And they said yes, definitely, and I can see that visibility also. Thanks so much for coming here on Saturday morning. I hope to share some interesting points which I could make out as I was going through these provisions once again. And I realized that life for chartered accountants and professionals is becoming difficult by the day. Yes, of course, for our clients it's becoming difficult, but it's becoming difficult faster for us chartered accountants also. And the sadder part is we are not even compensated for all the troubles that we take. And that's where I hope to share some insights with which I hope all of you will also take this back home and impress this upon your clients, both from an intellectual front as well as from a practice standpoint. And then please do emphasize to your clients that the work which all of you are doing is very sensitive, very tricky, and therefore you need to be compensated as well better. I also want to impress upon you the importance of our client acceptance and engagement terms with our clients, because the way the law is evolving, the way the regulatory environment is evolving, all of us have to be very particular on managing our risk and protecting ourselves from adverse consequences. So we will see the provisions of the PMLA and how it will impact all of us. And with that, I will just summarize some good to have things for all my fellow chartered accountants. So the PMLA is a fairly old legislation. It's more than 20 years old. And PMLA always used to do rounds in conversations primarily with economic crimes. And the way economic crimes were looked at, it was only looked at from the standpoint of terrorism, extortion, and black money and all that. But the law was amended first in 2005 to widen the scope of what is money laundering. And again, the push, so to say, rather, I just take a step back. The push for this money laundering legislation in 2002 actually was not something which came to our parliament on its own. It was driven a lot of it by external circumstances, primarily post September 2011, and the way the United States went about attacking terror funding. And at that time, actually way back in 1989, around 1989, the Financial Action Task Force was established, and that was instituted so as to address terror funding. Again, all of this had the backdrop of some small minor terror attacks in the US and in Europe, which took a lot of, took center stage, so to say, after the Gulf War, and the FATF has been fairly active thereafter. Post September 11, 2001, the focus on terrorism and its funding assumed more importance, and globally there were a lot of efforts which were put in to address terror funding and to attack terrorists through economic means. And in that backdrop, the PMLA was enacted. It was virtually toothless for a very long time. In fact, it was toothless until, I would say, 2019. When powers to the Enforcement Directorate were strengthened, although appointments were being made to the Enforcement Directorate from 2005 to around 2014, it assumed a lot of interest when the government started actively using the PMLA law to crack down on economic offences of any kind, rather than restricting themselves to terror funding, extortion, etc. They started using PMLA towards a whole host of activities. And that is why today, unfortunately, the discourse in the media is that the present governmental dispensation is using this against against its political opponents. It's unfortunately a one-sided narrative, because significant amendments to the PMLA were made way back in 2009 and 2013, before even the present political dispensation took over. So PMLA has been there in the books, has been there with its offices, but it has not been active. It has become active. In that backdrop, the reason why we are here today, I would assume it's primarily because of the two notifications which came out in May 23, wherein it specifically brought chartered accountants and other professionals into the fray of money laundering. I would say chartered accountants ought to have been sensitive or should have pressed the red button on money laundering way back in 2019, when some amendments were made to the law. Because as we will see, the concept of economic crime was widened, and anybody who was even a party to even one of the components of that crime could be brought to the book. Because economics, money matters, numbers is where chartered accountants step in. It was very difficult to exclude a chartered accountant from any activity which ended up as a crime. So, for example, we gave a tax advice to one of our clients. He took the tax advice and he applied it, and thereafter with the same advice, the outcome of that advice, he engaged in an activity which resulted in an economic crime. Right? So there, wouldn't the tax advise that chartered accountant also be implicated? That was the question which we used to get. And it was very difficult to say, no, the chartered accountant will be outside the ambit of PMLA itself. Alright. But not much attention was given to that issue. Only now, with the May notifications, has PMLA again come back to the limelight. But again, that's again a lot of media glare and all of that, because the implications of the May 23 notifications are very different. The implications of the PMLA law itself are very different, which we will see. So today's discussion, I will bifurcate it into two parts. One is the larger scheme of PMLA. Secondly, the reporting role of a chartered accountant given the May 23 notifications. There are two distinct roles for a chartered accountant. Okay, with that we will step into it. So it's a very interesting point to note that in November this month itself, the FATF is coming for a second evaluation of the PMLA law in India. It did this first evaluation around 2009 and 2010, and it came up with its review report in 2010 itself. And that 2010 report has been on the FATF website for the past 13 years. And the May 23 notifications are actually a culmination of that 2010 report. Alright? So I have taken snips from that report itself to bring to your attention that these amendments which have happened in the PMLA law over the past 10 years for that matter are all a culmination of this review report, and nothing new has come from our own people. Alright? So this is again a global effort. Alright? This is again a global effort, and India is only coming to terms with that global effort, and it is just catching up. So so the second evaluation is coming up now, and it's opposite that we at least catch up with the 2010 report before we await the outcome of this November 23 evaluation. Having said that, like I said, globally money laundering is something which is being attacked big time. The US was one of the first countries to attack this issue, and this knowledge and experience is something which shared with practitioners and authorities around the world, and that's how the PMLA law is evolving globally. If we see in that sense, the Indian PMLA law will be similar to many other country PMLA laws, particularly the UK, Canada, even for that matter the US. Although the US goes far deeper, but there will be a lot of similarities between our law and their law. Actually, these snippets which you see, para 19, para 22, are from that report. The next few slides are a copy paste because they beautifully capture why PMLA, how PMLA started, how it has evolved, why there is so much emphasis on this, and where we are today. So, the initial, like I said, money laundering was intended to attack economic crime, terrorism, drug financing, etc. Okay? And of late, recently we had these difficulties in Manipur, and that is when a lot of media focus went to the point that there was a lot of drug trafficking in our northeastern part of the country, and the disturbances in Manipur are actually a result of the tiff which the government of India has with those drug traffickers, right? And this seems so prescient. This was in 2010, right? This report is 2010, and they've seen all of this coming. India is a drug transit country due to its strategic location between the countries of the Golden Triangle and the Golden Crescent. India is the world's largest producer of licit opium gum for the pharmaceutical preparations, but it is estimated that between 20 to 30% of the opium crop is diverted. The illicit cultivation is mainly located in the areas of Arunachal Pradesh and Himachal Pradesh in the north of India. Arunachal Pradesh was something which even I wasn't aware of until last year. Then as the Manipur situation evolved, I got to know that cancer has spread through the northeast. And Himachal Pradesh was it was a tourist destination for opium, etc. It continues to be. And in that backdrop, prior to this, the paragraphs prior to this discuss about terror funding, which we've been seeing since around 1989 from Pakistan. And if you see the kind of economic crimes this report has itself envisaged. Economic crimes involve criminal conspiracy, cheating, criminal breach of trust, forgery, valuable security, will, using as genuine forged documents or electronic records, and other crimes of forgery are manifestation of frauds. These are beyond terror funding, drug financing. And today, these are the crimes which are coming to the forefront in front of PMLA. These criminal activities are amongst the major sources of money laundering as identified by the law enforcement agencies in India. The Directorate of Enforcement has been investigating various money laundering cases emanating from these offences. The cases investigated were related to the following offences: corporate frauds, forgery of documents. We know all of this. This is general knowledge for us. This was highlighted way back in 2010. Right? And I was just going through the ED website again, and I was just seeing where all they have their offices. They have significant strength, so to say, in Calcutta, Gangtok, and in the northeast, in Guwahati. There are extensive presence over there, and that's when I was just thinking the events are only catching up today. So actually, our government has been prepared for all of this. In fact, we talk so much about, at least in Bangalore, we talk about the ED being fairly strong. In fact, ED in Bangalore is a fairly small setup compared to the setups in Delhi, Bombay, Calcutta, and the northeast. And the whole idea is money laundering is concentrated in these areas. Bangalore is an area where there has been economic development phenomenally over the past 20-25 years, and money laundering has now come into Bangalore also. And as we will see, there are some specific areas, specific sectors where money laundering pops up, which is something which has been enacted into law as well. According to Indian authorities, proceeds of crime, can you see that phrase, proceeds of crime? That is what is enacted as law in PMLA. It's not something which the Indian Parliament coined. It is a global phrase, proceeds of crime, which we will see a little later. Proceeds of crime committed in India have been laundered in foreign jurisdictions. A number of cases of money laundering where the proceeds of crime have been transferred overseas have been observed. Based on the information, there are many others. Again, now, money laundering is one of the many laws which are connected. The black money law, the Benami Transactions Prohibition Act, alright, and the Overseas Offenders Law. Together with the Income Tax Act and FEMA, there are all these economic laws which today seek to combat economic crime. And of late, even with income tax, I'm sure all of you have seen the number of prosecution matters increasing for non-deduction of TDS, for deduction and non-payment or remittance of TDS. Our magistrate courts in Bangalore have been quite enthusiastic in affirming those prosecutions, right? However, right or wrong, but they've become very active, because of which the department is now taking a lot of interest in prosecuting. The income tax department is taking a lot of interest in prosecuting people, and it has joined the bandwagon, so to say, of the ED, CBI, etc. also. So, PMLA is one law in a constellation of many other laws, and all of these are fairly interconnected. So, for example, that's why, in that sense, the Income Tax Act and the compliances under income tax law are fairly foundational compliances. So, for example, if there is some illicit money which one of our clients has got, and he's offered it to tax in his return, and he's paid tax on that, that is one part. That will save him to some extent. That will save him to some extent vis-a-vis the other laws. But then there are other touch points in the other laws because of this offering. So, one button pressed in PMLA will press a few buttons in income tax and vice versa. One button pressed in Benami Transactions Prohibition will touch a few buttons in PMLA. Similarly, one button touched in income tax will hit the black money law as well. Right? And again, the FATF report also identifies diverse money laundering methods, and all of these are now formalized in the PMLA. So, para 27 of the same report, money laundering methods are diverse. In case of domestic crimes, the most common money laundering methods are opening multiple bank accounts, intermingling criminal proceeds with assets of a legal origin, purchasing bank checks against cash, and routing through complex legal structures. In the case of transnational organized crimes, the use of offshore corporations and trade-based money laundering are some of the methods used. Then comes this point of designated non-financial business and professions. The main notifications focus on the last row here, accountants. So, this phrase, this acronym rather, DNFPB, is something which was coined by the FATF way back about 20 years back, and the efforts of and the whole point is what the FATF says and what is acknowledged internationally is these 5 parties are the frontiers, so to say, of money laundering. These are the first touch points of money laundering. Therefore, they have to be brought into the ambit of the money laundering law. So, what the FATF says is that these 5 points are at the frontiers of money laundering. They are the first touch points of money laundering, and they have to be brought into the law. And the law had already brought in casinos, real estate agents, dealers in precious metals and stones, or PMLA 2002, had made amendments in around 2005 or so, bringing these first 3 rows into the ambit. Lawyers, it's not yet brought, it has brought in accountants in May 23. Right? So, if you see casinos, number present in India 20, are these DNFPB subject to AML CFT requirements? This is again in 2010. This was from the 2010 report. Yes. So, before 2010 itself, casinos were in the ambit of PMLA. They were supposed to periodically file returns before the ED, so to say. Supervisor regulator, State Home Department of the Goa government, because casinos were concentrated in Goa alone. Today, they are there even in the state of Sikkim, they are in the Union Territory of Daman and Diu. So that these are the 3 areas where casinos are there. Back when this report was drawn up, it was there only in the state of Goa. That's why this review which is going to happen by the FATF this month, we need to keenly await the report and see what it says. In fact, actually, thereafter this 2010 report says, while the law brought casinos into the ambit of PMLA, casinos faced a lot of difficulty in reporting the transactions because of operational concerns. The way the definitions were worded in the law, implementing them became very difficult. And therefore, it actually told the government that first you need to give some guidance as to how these casinos could comply. I could not find any of those guidances from the website, so I think the casinos continue to face the same problem. Thereafter, post 2010, I think in 2013, real estate agents, dealers in precious metals and stones were brought into the ambit of the PMLA. And in 2023, accountants have been brought. They are called as designated business and professions. DNFPB is the acronym I will use consistently, but this was part of the law. This is being expanded over time. So now the only set of professions who are excluded from PMLA are the lawyers. And the reason for that also, the very same report says that lawyers are slightly lower risk than accountants and company secretaries, CWS. So it's only a matter of time. Today, so what they say is, today the potential for a lawyer, the lawyer community to become a frontier is slightly lower vis-a-vis these guys. Alright, so let's see how PMLA compliance happens with these professions, and later maybe we will bring the lawyer community also into the fray. And as we will see, this is how it describes the situation. Lawyers are uniquely governed profession in India. The Bar Council oversees etc. Kindly see the fifth line. The assessment team was told that lawyers were prohibited from facilitating any financial transactions for their clients, although the basis for this prohibition is unclear. But they do routinely hold funds on deposit and in escrow for their clients. There exists a separate role for solicitation and fees are not allowed to be paid. Probably this was the reason why lawyers continue to be excluded, because they actually do not deal in money. Right? Whereas, let's see the next para, which focuses on chartered accountants and their role in economic matters. The chartered accountants are regulated by the ICA, which is a statutory body. Apart from auditing, chartered accountants are legally permitted to render management consultancy and other service. This activity encompasses, but is not limited to, the following services: financial management, planning, financial policy determination, capital structure planning, advice regarding raising finance, preparing project reports and feasibility studies, investment counseling in respect of securities, Alright. So, in that sense, chartered accountants are closer to an economic matter vis-a-vis lawyers. And these are the areas. And these are the areas which continue to be the focus, which were formally also brought into the PMLA. So, one of the questions which came was when this notification came, as auditors, should we be worried? As tax advisors, should we be worried about the May notifications? Right? About the May notifications, should chartered accountants be worried? The answer is no. Chartered accountants need not be worried. But they need to be worried about the larger PMLA dimension, not about the reporting. The reporting doesn't bother auditors. Right? As we will see a little later. Right? There are a specific set of activities of chartered accountants which will now require reporting. Specific set. Right? Which is what is the focus. The whole point there is Chartered accountants are not merely auditors, they do a whole host of other things. And that is the focus of the PMLA law in the main notification. Preventive measures, designated non-financial business and professions. So these comments here are what have finally culminated in the main notifications. Right? Following the amendments to the PMLA in 2009, casinos have been made subject to KYC, CGD and reporting obligation on the PMLA. None of the other DNFPB sectors have been brought within the AML-CFT network. The FIU IND, Financial Intelligence Unit, India has initiated interactions with the various professional bodies such as the Bar Council, ACAI, ICWI since January 2008 to draw their attention to AML-CFT issues and the vulnerabilities of these sectors in this regard. An interministerial committee was constituted by the government in 2009 to conduct a risk assessment. So there have been discussions with the ICAI, BCI on this matter. Right? So it's taken roughly 13 years for them to actually enact this. As regards the other DNFPB sectors, it is important that the government extend the PMLA to the businesses and professions as soon as possible. FATF told us in 2010, please do it as soon as possible. We took 13 years to do it. While the FATF standard does not envisage the complete exclusion of any of the DNFBPs from meeting the AML-CFT obligations, since they are all perceived to present a material risk, it is clearly appropriate to consider on a risk-sensitive basis the extent to which the range of requirements need to be applied. So they said, please bring everybody, don't exclude anybody. At best, you please introduce risk-based parameters as to when they will comply, when they will not comply, which has been now incorporated in the law. And all of this is a continuation of these efforts. According to the Indian authorities, the decision on whether to include designated businesses, precious gems, stones, real estate under the PMLA will be based on such issues as market share of the informal sector in each activity, the availability of information on the entities making up the sector, and the presence and scope of any existing licensing, supervisory or regulatory regime. Furthermore, the possible inclusion of designated professions will depend on resolving issues relating to the STR obligations. STR is suspicious transaction reporting, which we will deal with a little later, and professional privilege. So these two are very hot plates. STR, because the law says, the maintenance of record rule says, if these designated professions or these intermediaries identify any suspicious transaction, they should first not proceed to complete it, and they should, within 7 days of concluding that it is a suspicious transaction, within 7 days, they have to intimate the ED through the FIU portal. They have to make a submission saying this client of ours is engaged in an STR. There are formats prescribed. So now chartered accountants have been brought into this regime for specific activities. So those chartered accountants who do those activities have to keep their eyes open for suspicious transactions. But in discussions with the company secretaries and accounting sectors, the assessment team was advised that neither profession had any disagreement with being subject to the PMLA. 2009-10, Institute has had no problem with bringing us into PMLA. But there were ongoing discussions between the accountants and the government over the potential impact on client confidentiality. Because we have to report a lot of things, as we will see later. We need to see the nature of, we have to, as the choice of words, examine the ownership and credit worthiness or something like that. We will go through that a little later. So the chartered accountant should ask all those tough questions and should report about them. So the question which came up was, what about client confidentiality? What will that happen? How will that be protected? In addition, since Jan 2008, the FIU has initiated an outreach program to various professional bodies such as the Bar Council, ICAI, ICSI to sensitize them to the importance of AML. So this story has been happening for about 15 years now. Like I said, with that backdrop, now we will go to the law itself. Like I said, significant amendments were made in 2019. The provisions of PMLA were strengthened. ED was made more active, right? And the provisions were aligned to these FATF recommendations. Implementation was something which was seen extremely rarely until around 2018. Not many had heard about the ED. We had heard about the ED, we had heard some stories about the ED, again, primarily from a FEMA standpoint. So if there are FEMA violations, yes, the ED will pounce on us for the whole thing. Now, the ED is being pulled into, in say, for example, Lokayukta raids. There's a Lokayukta raid on a particular person. And if there's a person who's engaged with that with that entity who's been subject to that Lokayukta raid, the ED will call him, the CBA will call him, the Lokayukta will call him. Right? Earlier, the ED particularly used to be kept out because their focus used to be primarily FEMA-related violations. Now, for all these, all economic crimes, the ED is being pulled in. Right? That is the more important dimension. That has become stronger in the past 6-7 years. Calling for reporting. So, reporting requirements are also being strengthened in the PMLA. A facility has been provided to make those reports, and the whole point is now that we file the reports, how will they be used? So that only time will tell, and like the FATF had identified in the context of casinos way back in 2010, casinos themselves are finding it difficult to report. Now it will become even more difficult with chartered accountants, as we will see, because the language of the law itself is so tricky, so difficult to understand. Broad structure of the PMLA. So the law, the skeleton of the PMLA is something like this. It starts with definitions. Then it talks about the charge of money laundering. It says what is money laundering, attachment, adjudication and confiscation, reporting requirements, administration, which involves summons, searches, seizures, appellate tribunals, special courts, authorities under the PMLA. This is broadly the structure of the law. Money laundering internationally is recognized to have these three dimensions. First is placement, then layering, then integration. So basically converting of money by bringing illicit money into the system formally. Correct? Introduction of the illegal funds into the financial system done by way such as splitting a large amount into less conspicuous small amounts. Old trick in the book. If the Income Tax Act says payments more than 2 lakh will be subject to 269 NSS, okay, make it 1,90,000. Do it over 10 days, do it over 3 months, so to say. Old trick in the book. Right? Layering, continuous conversions, movements of funds within the financial or banking systems through multiple accounts to weaken the link of the funds to the origin of the transaction and to dispense them from the criminal nexus. So you move it from one account A to B, B to C, C to D, D to E, finally it comes back to A. Or it may not come back to A, it can come back to an associate of A. Right? That is layering. Integration. Funds enter the legit system, funds used to invest in real estate, jewelry and other assets. Cash goes into these assets. That's where these sectors, real estate, jewelry, are said to be the frontiers of the economy. And those sectors are the first to be brought into, earliest sectors to be brought into the ambit of PMLA. So what is money laundering? When will you be convicted or so to say held to be engaged in money laundering? This is the breakup of section 3 of the PMLA. Section 3 of the PMLA says what is an offence of money laundering. This is the breakup. I just split that section. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime. Okay. So, first the point is they should be connected with the proceeds of crime. Proceeds of crime is defined. Right? We'll go to what is proceeds of crime a little later. But then kindly see the parts before proceeds of crime. Whosoever, directly or indirectly. Directly, fairly okay, we can somehow pinpoint. Indirectly, at what stage will you stop? Right? That's why as chartered accountants we have to be careful. Okay, indirectly, very dangerous. We've seen that in the context of section 9 in the Income Tax Act. Indirectly was used to bring Vodafone to tax in India. Right? So this word indirectly is a little difficult to appreciate and draw a line, so to say. Attempts to indulge. So attempts to indulge, not indulges. Even attempts to indulge, he gets caught. He will not only indulge definitely he will get caught. Even if he attempts and fails, attempts and succeeds, attempts and fails, he lost it. Okay, will come. Right. Kindly see the choice of words. Attempts to indulge, knowingly assists. This is the red flag for us all chartered accountants. Assists. We will give them the tax advice. We assisted them. Did we knowingly assist them with respect to proceeds of crime? That is the subject. Knowingly assist. When will we knowingly do it? This boils down to the concept of motive in criminal law. Right? The Indian Penal Code, the Criminal Procedure Code, the evidence law, all of them talk extensively on motive. Vis-a-vis a crime. What is a motive? Who has a motive? When can you say that he had a motive? What constitutes motive? What are the examples of motive? What are the examples of there being no motive? Right? So this knowingly assists is a very, very important phrase for all of us. Right? It's a very thin line. Right? So we knowingly assisted in an activity, but we did not know that it will culminate in or conclude in a proceeds for crime. But then that distinction the law does not make, because later on it says any process or activity connected with, not culminating in. It says connected with, not culminated or concluding in. That is what makes our life extremely difficult. Right? Knowingly assists or knowingly is a party or is actually involved. Actually involved is fairly straightforward. Any process or activity. Now, what is a process or activity which culminated or which is connected with the process of crime? So we have to go to the history of the crime and see what all resulted in the crime. Now, how do you call one process, one activity vis-a-vis other? Extremely difficult. We venture into criminal law. Actually, we should venture into criminal law to understand all of this better. But then, that will be a larger subject, which I will not venture into. Just to highlight to you the sensitivity of the language in this provision. Right? Knowingly assists, directly or indirectly, knowingly assists any process or activity connected with the proceeds of crime, including its concealment or possession or acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offence of money laundering. This is a large definition of money laundering. So, for example, a car was stolen. So, a classic example which they give is I gave my friend some money, say about 10 lakh rupees. With that 10 lakh rupees, that fellow bought a car. Okay, and with that car, he committed a terrorist attack. Okay, my so-called friend, he committed a terrorist attack. Now, I will be behind bars because I have given him the money. Simple. I did not know that that friend of mine will become a terrorist. Sorry, that doesn't matter. Because the word again is connected. Right? This is to give a very crude example. Right? That is the far-reaching dimension of money laundering, and why we chartered accountants should be really be thinking through on this point. Okay? Person shall be guilty of money laundering if the person is found to have directly or indirectly attempted to indulge or knowingly assist or knowingly is a party or is actually involved. So that's okay. Now, what is process of crime? Process connected with, we go to process of crime a little later. Process connected with proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting as untainted property. Another example. I gave a friend of mine about 30 lakh rupees, and with that he purchased a house. He rented that house to a guy who became a terrorist. Okay. After that, the terrorist went behind bars. Okay, I rented that property out, that my friend rented that property out to somebody else. Alright, And then when they were in the course of the investigation, they got to know that the terrorist was living in that house, and that house was funded by me. My friend will project that house as a legitimate asset of his. Right? He will call it as his legitimate asset. He borrowed money from me, he invested in that house. It's his normal asset. But then both me and my friend will be held. Why? Because we are connected. Whether we did deliberately or not is another matter. If we do it deliberately, it's even worse. But this is the far-reaching dimension of this concept of proceeds of crime. So this guy went behind, he was arrested. Okay, and this happened say 10 years back. I gave this money to him 10 years back. Okay, this was used as a house. This was used to build a house, and thereafter this guy came to live in. So on a 10-year-old transaction, I will be held responsible today. That is where this point of it is a continuing activity. Because my friend, he will call this house a legitimate asset. Right? That is the important dimension of money laundering. It will haunt us for the rest of our lives. There is no limitation. There is no limitation in money laundering. Yes, we can definitely say, 10 years, we can take that plea, but it won't stand. It has no support of the law. Limitation law does not limit it. 12 years, 3 years, 10 years, whatever. It's a continuing activity. So if 20 years back I gave him some money, even that will definitely have an impact. Here, the key question for all of us chartered accountants is abatement of knowingly assists. Okay. Have we abated that crime? This word abatement has been subject to a lot of discussion and litigation over the years, because the word abatement, it comes from the Indian Penal Code. It's imported into the Criminal Procedure Code. All of these go close to 100 years back. So there's a lot of literature on when something constitutes abatement, when something does not constitute abatement. Right? That's the abatement. We somehow equate it, make it synonymous with knowingly assists. Alright, so that is where these two questions: can chartered accountants, by merely advising on a transaction that even remotely results in money laundering, be regarded as having committed the offence of money laundering? Question mark. This question mark only. What if the chartered accountant's client is subject to proceedings by the CA or ED, and he, by not identifying during audit or during filing of a tax return that is proven to be false, or by merely being his tax or transaction or business advisor, will this be money laundering? Satyam's case to the matter, right? It went into, today that case is virtually dead, but had the money laundering provisions been invoked, would the outcomes have been different for everybody in the arrangement? Because when Satyam happened in 2009, PMLA was one of the last laws which were examined. It was more of a SEBI matter and criminal investigation matter. It never went in this tangent, so to say, of tangent, or rather it's the right road of money laundering. What would have happened if it had gone through this road of money laundering? Something which we have to ask. So that's where the question comes: when we do an attest function, are we abetting something? And that's where this attest function has become an extremely challenging area of practice for all chartered accountants in recent times. I'm sure all of you would have seen the numerous reports of the NFRA. Right? When do we say yes and sign a set of financials? How much do we trust our clients? How much do our clients trust us? How much do we know our clients? How much do our clients know us? Right? Very important questions which goes to the very foundation of a chartered accountant's work, is attest function. Right? That's where the money laundering law, the alarm bells were sounded way back in 2002, emphasized in 2005, again emphasized in 2009. It became a red flag big time in 2019 only. But even then, very few people appreciate the nuances and far-reaching implications of PMLA. And that's where lawyers are the first one to call PMLA draconian. They virtually equate it to Tada. Tada, the first adjective which comes was draconian, draconian Tada. Similarly, draconian PMLA. In fact, Benami provisions and black money provisions are so much more better because the power of arrest in those laws are slightly slightly weak. The powers of arrest in PMLA are very strong. That's why it is called draconian. The other reason why PMLA is called draconian is it overturns the burden of proof. It presumes a person guilty until proven innocent. One of the very few laws which presume a person to be guilty until proven innocent is PMLA. Everywhere else it's the other way around. Some court will always come to rescue us if the burden of proof is overturned. Here the law itself says that clearly, as we will see. Okay. Hierarchy under the PMLA, just to give again an overview of the PMLA. So, trial of offence of money laundering. So, once you are held to be held to have engaged in money laundering, the right side hierarchy kicks in. There is a PMLA special court which will conclude that yes, you are engaged in money laundering. You can appeal against the PMLA special court's order before the High Court, thereafter to the Supreme Court. When it comes to attachments, so one of the again so-called draconian dimensions of PMLA is the power of attachment. Okay, so that house example which I gave in the context of the terrorist, that house can be attached. The attachment happens in the left side hierarchy. The Deputy Director of Enforcement, he should make a reference to an adjudicating authority. If he confirms, if they confirm it, you go to the PMLA special court and then High Court, Supreme Court. So there are two sort of hierarchies in the PMLA, one to deal with attachment, one to deal with the offence of money laundering itself. Right? These are two parts. So what will happen if we are held to have engaged in money laundering? One is our property will go. Alright? Property will go. Secondly, we will also go behind bars. Punishment for money laundering. Rigorous imprisonment for not less than 3 years, but which may extend to 7 years and also fine. In specific instances, it could extend to 10 years. Okay. So left side will take us into prison. Sorry, right side will take us into prison. Left side will take our property away. That is why PMLA is called draconian. Because you look at Indian Penal Code or criminal law, it will only put us behind bars. It will keep our asset intact. So after our imprisonment we can move on in life. Right? But PMLA, even after we come out of jail after 7 years, we don't have anything to start our lives with. That's the dimension of PMLA. This is one dimension of punishment. The other dimension is on the reporting. So we will see reporting. Reporting entities, they have to maintain transaction records, therefore they have to furnish it to the director, they have to do all of this. Where above information is not maintained, director are empowered to impose a fine, that's all. They are very considerate, here they will only impose a fine, nobody will go behind bars. Okay, unless that person is engaged in money laundering, that very same person is engaged in money laundering. For example, a real estate agent. He has to maintain all these records and file them. If he doesn't do, he will pick up a fine. If he is engaged in money laundering, of course, all his assets and both of them, will be free in that sense. Okay. Above order imposing fine applicable before the PMLA. Burden of proof. This is the point I was mentioning. In case of a person charged with the offence of money laundering, the presumption is that the proceeds of crime are involved in money laundering unless the contrary is proved. That is the presumption, legal presumption, that you are guilty until proven innocent. Okay, so the burden of proof is reversed. Okay. What are the offences? Okay, starts with criminal conspiracy under 120B. Extremely wide understanding of criminal conspiracy. Courts have interpreted criminal conspiracy under 120B. Alright, very widely, and that is where in fact all our so-called tax planning structures, if there is some bit of malafide involved, it will actually become criminal conspiracy. If we read the commentary in the Indian Penal Code on 120B, we'll get to see the far-reaching understanding of criminal conspiracy. Right? Others are fairly straightforward: dishonestly receiving stolen property, habitually dealing in stolen property. These are clear black marks. This criminal conspiracy is a fairly grey area. Punishment for cheating under 417, 420, counterfeiting device or mark 475, 483. All these are clear crimes. This criminal conspiracy, again, that mala-fide intent, mens rea. That mens rea, for a crime, mens rea should be there. Alright, but how will you ascertain that mental element is something which courts have interpreted extensively in the context of section 120B of the Indian Penal Code. Offences under Prevention of Corruption Act also straightforward. Offence relating to public servant being bribed, bribing a public servant, punishment for abatement of offences. Fairly straightforward. SEBI, this is where white collar crime comes in. Apart from criminal conspiracy, white collar crime starts coming here. Prohibition of manipulative and deceptive devices, insider trading and SAST are controlled under sections 12A and 24. The white collar crime. Next is also another case of white collar crime: evasion of duty or prohibitions under section 135. Right? This again is considered as a cross-border crime because it involves overseas imports, exports. Offences under Companies Act, punishment for fraud under 447. Offences under Customs Act of 1962, false declaration under 132. Willful attempt to evade tax under the black money law. Right, undisclosed foreign income. So we have foreign assets, we've not reported it in our return. One of our clients has foreign assets, he's not reported it in his return. It's a technical violation of the black money law. I do not have an answer to this. Right, technically it's a violation of the black money law. Okay, we can always ask for compounding, lenient treatment of the case. We can plead. Not sure whether we will win. I'm sure all of you would have recently seen this ruling of the Mumbai ITAT, wherein foreign asset disclosures were first introduced in the income tax return in around 2016 or 17. This taxpayer, he had been offering that foreign income to tax, but he had missed reporting that foreign asset in that return. Okay. He did that for the first time, I think, in 2019 or 20. So for 2 years he had missed out. The officer initiated penalty proceedings for all of this. He levied the penalty. They went on appeal saying they gave a whole host of reasons. But the Income Tax Appellate Tribunal Bombay affirmed the penalty. It was, when I saw that ruling, I was terribly disappointed. Because, yes, the arguments could have been better, of course. But then the thought process, decision-making process of the judicial authority was something which came to the forefront when it came to foreign assets. There is a taint when foreign assets are not disclosed in our return. That is the inference which I could draw from that ruling. Authorities, forget authorities, courts will not consider your case fairly if you do not report them. The fact that it was the first year of reporting did not even occur to the tribunal. They simply said, just because you reported that income does not mean I will give you a clean sheet. You should have reported the asset. What if you had reported income of 10 lakh on a foreign asset of 10,000 crore? Was, I suppose, the thinking which went behind with the tribunal's judgment. But that's again in the realm of imagination and speculation. But that is that far-reaching impact of this undisclosed foreign income and assets imposition of tax act. Okay. So, very, very innocuous law, but very far-reaching law. Okay. Now we'll just come to the definitions which are there. Beneficial owner is defined. Beneficial owner, this concept has been debated for the past 100 years internationally. Who is a beneficial owner? It's becoming, it has been very difficult to define. See, for example, with individuals, partnerships, etc., this issue does not arise. This issue arises only in the case of corporates and trusts, wherein the ultimate owner in that sense is not seen. So the question is, how do we identify the beneficial owner? Right? And this has been for the past 100 years beneficial owner has been debated. The OECD has had extensive deliberations on beneficial ownership in the context of double taxation treaties. Even today, the OECD is extremely vague in defining who is a beneficial owner. But then, especially after September 11, there was extreme pressure from the US to highlight all of this, because finally when they went down that rabbit hole of seeing who had funded the terrorists who hit the World Trade Center, they somehow or the other it pointed fingers indirectly to the Middle Eastern royal families. Alright? But then they realized this is what it is, and that's when they started putting thresholds and defining beneficial ownership more clearly. So the question which we have as international tax practitioners is to understand this beneficial owner in the context of cross-border taxation. Can we bring in this definition of PMLA? We bring in this definition of PMLA, we are done for. All these foreign companies are done for, so to say. Anyways, beneficial owner means an individual who ultimately owns or who ultimately controls a client of a reporting entity, or the person on whose behalf a transaction is being conducted, and includes a person who exercises ultimate effective control over judicial person. This is a subjective definition. Okay, for all you know, one organization can be ultimately controlled by multiple people. What do we do in such a scenario? Right? That is why there has been a lot of evolution on the understanding of beneficial owner, and today the 10% threshold is something which is considered. So anybody who controls 10% of multiple parameters is considered a beneficial owner. We see that definition in Rule 9 of the PMLA Maintenance of Records Rules of 2005, which we will deal with briefly a little later. Reporting entity means a banking company, financial institution, intermediary, or a person carrying on a designated business or profession. So when PMLA came in initially, reporting entities were supposed to file some reports. Banking companies, financial institutions, and intermediaries were clear participants there. Right? Banking companies, all are banks. Financial institutions are NBFCs, and intermediaries, all those people who are regulated by the SEBI, stockbroker, investment advisor, investment manager, right? All those guys came under this definition of intermediary. This person carrying on designated business or profession is the same DFNBP, which we saw a few slides earlier. That they had not expanded it until recently. Until recently, maybe about 10 years back. It started off with casinos. Then it expanded to real estate agents and dealers in precious gems and jewelry. Today, that person carrying on designated business or profession includes a chartered accountant, CS or CWA, and undertaking specified activities, and the other set of people. So this is the bane, so to say, today. Reporting, because there's a lot of ambiguity, as we will see a little later. Client means a person who is engaged in a financial transaction. Financial transaction we will come back to a little later. A person who is engaged in activity with the reporting entity includes a person on whose behalf he is engaged with money laundering visa. Offense of cross-border implications. Any conduct by a person at a place outside India which constitutes an offense at that place, and which would have constituted an offense under Part ABC of the schedule, which is the blue table which we saw a few slides back. That is Part ABC. Had it been committed in India. So basically it defines offense of cross-border implications. Let's leave it at that. There are difficulties there, but let's not spend much time there. Person carrying on designated business or profession. Subject matter of May 2023 notifications. Playing games of chance for cash or kind and include such activities associated with casino. Okay. Then Inspector General of Registration appointed under Section 3 of the Registration Act. This is sub-registrar offices. These are all sub-registrar offices. Real estate agent as may be notified by the government. Dealer in precious metals, precious stones and other high value goods as may be notified. Person engaged in safekeeping and administration of cash and liquid. This is the CSDL, NSDL or depositories. Person carrying on such other activities as the central government may by notification so designate from time to time. These are our May 23 notifications. So the two notifications which came in May 23 are based on this clause of that definition. Proceeds of crime. We saw that we were talking about proceeds of crime. What is it? Proceeds of crime means any property derived or obtained by any person as a result of criminal activity relating to a scheduled offence, or the value of any such property where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. Proceeds of crime include property not only derived or obtained from the scheduled offence, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity related to the scheduled offence. Extremely wide definition. I got paid because I was a terrorist. I will give very blunt example. I got paid because I was a terrorist. I did some activity. 10 lakh, I was given 10 lakh. With 10 lakh, I bought a house. That house constitutes a proceeds of crime. There was a criminal conspiracy of insider trading. Right? We were convicted of insider trading by the SEBI. Even 120B proceedings were initiated, and then we were convicted there. We made, say, 3,000 crores out of that insider trading, or whatever gains we made out of that insider trading. That becomes proceeds of crime. Assume for a moment those proceeds we have invested in some asset. Those assets become proceeds of crime. Alright? Then the question comes, there was cash lying with us. There was a guy who was engaged in insider trading. He made about 300 crore of gains. Out of that 20 crore, he gave it to me as a gift. 20 crore he gave it to me as a gift, bona fide. I did not know that he was engaged in insider trading. That insider trading allegation, etc., came 3 years later. Okay, today he gave me a gift. So the illicit, so-called illicit gains were about 300 crore. Out of that 10-20 crore, he gave it to me as a gift. Even that 10 or 20 crore constitutes proceeds of crime. Technically. Practically, and that only time will tell. Technically, it's a proceed of crime. This is the implication of this definition. Property, again, very defined. Whether corporeal, incorporeal, movable into everything. Okay. And that is the concept of PMLA. So, again, just to summarize, the activity of money laundering has been extremely widely defined. Primarily, there should be proceeds of crime, there should be a criminal activity. Again, criminal activity, proceeds of crime, we need to understand those concepts in light of criminal law, the Indian Penal Code and how it has interpreted it. You are guilty until proven innocent, and the whole idea of proving our innocence boils down to evidence, which is a very difficult task in the context of a criminal offence. And especially for chartered accountants who would contribute minorly or majorly in an economic activity that culminates in a criminal activity, even that chartered accountant could be held responsible. The point is, how do we draw lines? How do we tell our clients, no, we will not advise you on something? Right? That is a point to think about. Right? With that, we will close our discussion on the PMLA conceptual part. Now coming to the part on reporting requirements, which is the subject matter of the May 23 notifications and the impact for chartered accountants there. So section 11A of the PMLA talks about reporting. And it says every reporting entity shall verify the identity of its clients and the beneficial owner. Okay? Every reporting entity shall verify the identity of its clients and the beneficial owner by Aadhaar identification, offline verification under Aadhaar, use of passport, use of any other officially valid document. All of this, if you recollect, are our KYC, which our banks do on us. Our banks do know your client process. That is exactly this. Okay. We've seen all of that being done by banks. We've seen all of that being done at the sub-registrar's office. We've seen all of that being done by NBFCs. Now, even chartered accountants who perform specific activities have to do the same KYC. That requirement is enshrined in section 11A of the PMLA. So, the difficulty here is clients, if they are individuals, corporates, identification should be straightforward. This is even as part of the code of ethics of the institute. Engagement acceptance, client acceptance process. There is elaborate discussion on client acceptance and engagement acceptance process in the ICA Code of Ethics. We just have to look that up and we will get our answer. The difficulty is with this beneficial owner. We have to do the KYC of the beneficial owner also. Okay? Domestic clients, fairly straightforward. Right? They are within the country. Yes, they will be reluctant. If they are reluctant, I mean, life is difficult. But with overseas clients, it becomes quite difficult. But then, one thing which we have to sensitize even our overseas clients is that they will have been doing the same compliance KYC even in their home jurisdictions. Especially if they are from, say, the US, UK, Europe, Singapore, all those large popular jurisdictions. If they are from there, they are anyways doing their KYC there. So all they have to do is share the same set of documents there. Right? And that's the fantastic part about the FATF. What it has done is it has aligned KYC norms around the world. See this last bullet here, use of any other officially valid document or modes of identification as they will notify. This is something which the Indian government has also notified. Again, the maintenance of record books actually state for non-resident what you have to get. You have to get it attested by the embassy, all of that stuff. So attested by the embassy, whether it can be apostilled, all of that is fairly aligned, so not a problem. But the good thing again, right? Finally, the good thing is it's this requirement is virtually global and globally aligned. Right? So it should not be actually difficult for our clients to share information on KYC. So now the question comes, now that chartered accountants, so we'll go to the May notification and we'll come back to this. So first let's see the May 3rd, 2023 notification. There was one notification on May 3rd, 6 days later on May 9th there was another notification. The May 3rd notification is the notification specific to chartered accountants, CWS and CS. Okay? Financial transactions carried out by a relevant person. Okay? Financial transactions, please see the words. Financial transactions carried out by a relevant person. So relevant person, CWA, CS, on behalf of his client, on behalf of, not for himself, on behalf of, okay, on behalf of his client, in the course of his business, his or her profession, in the course of his profession. So he should provide that, he should undertake these activities as his profession. So for example, profession in relation to the following activities only. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Buying and selling of any movable property, managing of client money, management of bank savings or securities accounts, organization of contributions for the creation, operation or management of companies, creation, operation or management of companies, LLPs, So, CA, CWS, CSS who do only these 5 activities are supposed to report. So, our auditors required to report? No. Our tax advisors required to report? No. If you provide GST return filing assistance, are you going to report? No. If you are filing a tax return for them, income tax return for them, are you going to report? No. It's only these 5 activities you have to report. Okay? And these chartered accountants or CWS, CS who do these 5 activities now have to ponder what to report, when to report, what time, etc. Okay? So if we take buying and selling of property, what are some difficulties with these languages? First, we will just go through. Okay? So now the other part is RP to undertake these activities in the course of his professions. This is restricted to CA, CWS or CS. So if a non-CA, non-CWA or non-CS does these activities, it is not covered. It is not covered under this notification. Alright, or it is actually not covered anywhere. But the way the laws visualized it is, these are activities which are typically done by chartered accountants. They could also be MBAs. Right? Therefore, it's a fairly wide net, and typically non-CS, non-CWAs not being covered in this definition, very limited, unless they are lawyers. Unless they are lawyers, who are anyways excluded, because they are not relevant persons. So, the next development in this could be lawyers being included in this definition of relevant person. Okay? Next, one important point in the context of buying or selling immovable property. What if the chartered accountant has been given a POA? He will be covered. he will be covered. So, triggers when the reporting party actually does these activities otherwise than an intermediary or defined DNF PPT. So now these other 4 activities, if you see managing of client money, managing of bank, organization, all these last 4 bullets, alright, these somehow they come under this classification of intermediary for SEBI law. So for example, investment managers, okay, investment advisors are required to be registered with the SEBI. And so they have a SEBI oversight on them and they are called intermediaries under SEBI law. And anyways, these guys were required to report it even earlier. So only those people who have not been covered by SEBI earlier will now come under this ambit. And then, see what happens here is many chartered accountants would be doing their audit work, they would be doing this work for other people as well. Alright? And the dimension is to bring within the PMLA ambit those people who are outside SEBI framework. SEBI framework, anyway, there is one authority overseeing them. Is there anybody outside the SEBI framework? This notification seeks to bring them into that ambit. Now the other point is managing of client money, management of bank. What do you mean by managing? He has 10 bank accounts. 9 bank account he manages. 1 bank account the chartered accountant manages. Partly or wholly, we have that debate, right? We play around with those words in income tax law, GST law, FEMA, etc. We can't play around here. It doesn't make a distinction. So even if we manage 1 account, we are done. Again, because see, the word manage is a very wide word. In the income tax context, the Delhi High Court had earlier extensively had defined this and given a wide meaning to the word manage. It said management sciences include da. We have to plan. If you plan something and execute it, definitely covered. If you plan something, don't execute. You ask the client to execute it. Possibly you will still get covered because you are managing it. You're only asking him to affix his signature and then say remit or something like that, or say sign something like that. But then you're taking all of the key decisions for that transaction. That is when you will be covered. Alright. So the word manage is extremely wide in nature. Again, next, fundraising activities in any manner covered. So if we help an entity in raising money, we give them advice. Would it be organization of contribution for management of companies? Or would it be creation, operation or management of companies? Yeah, so creation, operation or management, fairly straightforward, slightly narrow. Organization of contributions for the creation or operation or management of companies. Again, interesting question. So fundraising activities, if we help them raise a loan, if we help them raise equity, we get one investor into their company, we get a success fee, something like that. Would we be covered? Answer is yes. Okay, it's easy to stand here, say yes. Then when we see the forms, it will become difficult, which we will see. Okay, that's where the difficulties which the casino operators expressed to the FATF in 2009 echoes to this day. With casinos, at least, life was a little easier. There are black and white transactions. Right? Somebody comes, he says, I have 10,000 rupees, give me coins for 10,000, I will play at the tables. That is the start of an arrangement. But with chartered accountants, how does it work? He will say, over a phone, he will say, Bharath, I am looking at raising about 10 crore. Do you know any investor who can help me there? Over a phone, I will say, yes, actually one of my clients was looking at a company, yours is a good fit, let me put you in touch with him. 2 weeks later, they go through the deal, I get one small fee. I have helped them fundraise. When did it start? When did it end? Before it started, and rather before it, I have not even done the KYC. The transactions ended. Right? With casino operators, it was at least easy. When that fellow comes into the casino, it starts. But here, because you don't know whether the transaction will go through. My contact may say, no, I'm not interested, let's drop it. Okay, then I would wonder, why should I do the KYC? Right? With with these specified activities, when is the transaction starting, when is it ending, becomes extremely difficult to identify. Okay, that is the challenge which we will see a little later. So managing part of whole ought to be read as even a part, given the larger context of the law, for gathering information to curb economic crime. So that's why I was saying yes, it will apply, is because as we will see in one of the provisions, it says they will want to construct the entire sequence of events. So I think it is, section 12, it uses this phrase in such a manner. Kindly see the first sub-bullet. In such a manner as to enable it to reconstruct individual transactions. The reason for all of this reporting is to achieve this end of reconstructing individual transactions. So to reconstruct individual transactions, you should have all the individual transactions in place in the first place. It may have ended up in an insider trading activity, but then there will be many other sub-processes which have culminated in that. In the financial world, it is so difficult to identify all of it. Where does one start, where does one end? Yeah. So a similar wide reading ought to be given to organize, create and operate in the absence of any definition. Right. At least with income tax, GST law, we can look at specificity to the meaning of a word. Right. With FEMA, it becomes extremely difficult. It's the same way with money laundering. The choice of words are not, the words used are not very specific. Organized. It's a verb as well as an adjective. When adjectives come into law, it becomes very difficult to implement the law. So when you use the word organize, okay, what do you mean by organize? And if you just ponder with whatever little English we know, it becomes difficult to pinpoint the meaning of organize. Similarly create, similarly operate, becomes very difficult. And that is where, given the consequences of non-reporting, coming into the bad books of PMLA authorities, we should actively think, okay, we will comply. But then the difficulties will continue there, which we will see a little later. Okay, so in this backdrop, we saw one set of reporting entities, our chartered accountants. The other set came out in May 9, 2023 notification. Following activities, when carried out in the course of business on behalf of or another person, as the case may be, okay, acting as a formation agent, acting as or arranging for another person to act as a director, providing a registered office, correspondence or administrative address for a company, acting as or arranging for another person to act as a trustee, acting as a nominee shareholder. Okay. Now, all of these need not be chartered accountants, company secretaries, CWs. Anybody who becomes this comes under the reporting requirement. Okay. So let's spend a little time with each of those red underlines. Again, carried out in the course of business. Earlier we saw carried out in the course of profession. Here, this is their business. There it was their profession. Okay. So, first, as a good example, formation agent is a good example. Formation agent is a concept actually which is there in, and these are some exclusions. So, if a chartered accountant enters into a rental agreement with a client, okay, and he takes rent, that will not be covered because it's a landlord-tenant relationship, not a business relationship. It's a landlord-tenant relationship, therefore it is excluded. An activity that is carried out by an employee on behalf of his employer. Here it is an employer-employee relationship, therefore it is excluded. An activity that is carried out by an advocate, chartered accountant, so-and-so, to the extent of filing a declaration. This is a statutory relationship, that is why this is excluded. Any activity of a person which falls within the meaning of intermediary as defined. This is excluded because this is anyways covered by SEBI. So these exclusions have some particular reasons to come out. So all the others will simply come under the definition. Thereafter, reporting party to undertake these activities in the course of his profession, not applicable to CS, CWS, like I said. Okay. Applicable to non-CA, non-CW or non-CS who does these activities as his business, not profession. Now, the other question is whether a lawyer doing this, right, a lawyer doing this in his individual capacity triggers this notification. The answer is again verbal gymnastics. Lawyer does this as his profession, not as his business. But if he incorporates a company and that company acts as a formation agent, yes, it applies to that company. Right? These subtleties also we should be able to appreciate. I mean, I'm sure it's not a black and white answer because the PMLA law will say, boss, I'm looking at tracking economic crime. Please don't involve in verbal gymnastics. Please don't teach us English. Okay, so it's a tricky road to walk on. Applies to individuals and non-individuals who typically provide company formation and management services. Okay, so all of these, if you see, are company formation, company management services, which are there extensively in the US, UK, and these all are exotic locations. British Virgin Islands, Mauritius. There are trust companies, company formation companies who are actually called formation agents as per their respective law. This is someone, it's a drafting, I simply believe this is a drafting oversight because formation agent is not an Indian concept legally. It's a UK and Singaporean concept. They've done some copying and pasting, but then I'm sure they will interpret it to mean anybody who assists in incorporation of companies. Anybody who assists in incorporation of companies, we will bring it to their, we will bring them into the ambit of PMLA. So how to interpret? Can all entities which assist in incorporation be considered so, especially when they provide services on a principal to principal basis rather than, again, this is all teaching English. Formation agent, that's the use of the word agent. I am not an agent. I am providing services on a principal to principal basis. Don't call me agent. We can involve in, we can participate in these theatrics. But then they will say, boss, you are assisting in incorporation. Please leave. Please report. In the case of a person acting as and arranging for another person to act as, would both persons constitute DNFB? Okay, so this definition, it says acting as or arranging for another person to act as. A company provides incorporation services. It also says, I will send this person as director. You need 4 directors, assume. 3 you bring, 1 nominee director I will give you. Okay, so should both be reporting entities? Should both be reporting entities? Is the question. Okay. Again, there the question, the answer to that lies in this phrase carried out in the course of business. Is that fellow who became the director, is his business to become directors? So, for example, independent directors won't come into this category because their business is not to become directors. Their business, they have their own profession. As part of that, as part of a larger role, they are becoming independent directors. But there are some people who do only directorships. In such cases, so if you look at shell companies, so-called shell companies, you will have the same nominee director in some 20-30 companies. Okay. Those are the ones who will get covered. So there the point is whether both of them have to be reporting entities. Answer is yes. Why? Because money laundering seeks to attack such structures, rather not attack, seeks to get information of such structures. Providing a registered office, business or accommodation, correspondence or administrative address. Here, one question which came was providing a correspondence address, typically understood it as physical address, post office, post box, and all of that. But then, would also mean providing an email address. Income tax assessments are today happening on a faceless basis. As long as the email address is accurate, we can finish the assessment without even receiving a physical notice. Right? This we need to keep in mind as information and communications technology evolve. So, can we say this address in this third sub-bullet is physical address or virtual address? Also. Okay? Acting as or arranging for another person to act as a trustee, similar to the directorship idea. Right? Now with this, we will go back to identity verification. So all these ways, people who do these activities should do the KYC. Like I said, clients possible, very easy to get. Beneficial owners, what to do? That is the going to be the challenging area. Again, in the context of KYC itself, there have been a lot of discussions, and the RBI, way back in around 2002 itself, when PMLA was enacted and when this reporting entity requirements came in, it had to give a framework for banks and NBFCs. And there are these master guide and master directions of the RBI on KYC. Beautiful document. I mean, it's been amended virtually every year. Very nice document on KYC. Gives every answer which a chartered accountant will get when he does his role here in the context of KYC alone. Others are the CA's headache to solve. So, verification of client and beneficial owner distinct from transaction itself, which is direct separately. So, first there is a KYC and then there is transaction reporting. So, now we will see KYC. Transaction reporting we will see in PMLA in a few minutes. Okay, when does one become a client? Identity of his client. Chartered accountants, when does one person become a client? With a bank, it's straightforward. When somebody goes to open an account, that is when he becomes a client. Okay? For us, when does he become a client?
Phone when he speaks, asking for some clarification.
Sir, sorry.
Over phone when he has some clarification.
My friend calls me up, asks for a clarification. An old client. He was there 5 years back. Today he remembered me and asked for a question. He asked me a question. Okay, I gave an answer. I didn't charge him. I did not charge him. Did he become my client? That is the difficulty which chartered accountants, CWS, CSS will face. Okay, on those specific professions only. Buying and selling immovable property. The chartered accountant is good at immovable property transactions. He will ask him a question. Okay, and he will help him, and maybe he will do a few discussions, and over phone itself the transaction will get concluded. So, when does he have time to do this? First he has to fix, no, right? When did he become a client? It starts there. The difficulty starts there. When does one become a client? Importance of on the slides I can easily say importance of signing up formal engagement letters. This works in a structured assignment, in an audit exercise, in a valuation exercise, all of this works. But in things like managing all of these, yes, there is definitely engagement letters which will get signed up, definitely. But this example which I gave, in that example, when will the transaction, how will I sign up an engagement letter? What about prospective clients? There is no adjective before client. Does it include prospective clients? Why I am asking this question is later on, the law says, I have to furnish to the director, kindly see the second sub-bullet, within such time as may be prescribed, information relating to such transactions, whether attempted or executed. Attempted transactions also I should give him information. So, prospective client also I should keep some information. That is the difficulty. Right? All these sections are interconnected in this manner. We can't see one independent of the other. And then another difficulty which comes, beneficial ownership. Beneficial ownership, again, fairly straightforward. Defined in Rule 9 of the Maintenance of Records Rules. Sensitive question. Some considerations when listed entities and trusts, nominees and fiduciary accounts are created. There is good enough guidance which we can use. Documents to be obtained for each type of person that the reporting entity deals with, individual firms, corporates, trusts. So for all these different types of persons, different KYC norms are prescribed in terms of documentation. So we just have to see that and we will get the information. Approach for non-residents undertaking these transactions, again guidance is there in the Maintenance of Records. So just like if we were to get a PAN for a foreign company, PAN for a foreign national, what do we do? More or less the same information we need to collect from a KYC standpoint. Again, not just passport. It should be a passport attested by the Indian Embassy. Right? So we need to be sticklers in following those guidelines there on KYC. RBI Master Circular on KYC AML regularly updated and available at this link. So I've shared the presentation with the chapter, so I'm sure that will be available to all of you guys. Now, This information is to be kept for a 5-year period. Okay. That's when good practices on our office filing, hard copy, soft copy documentation, all of that is extremely important. 5 years we need to keep this. Again, this 5 years, we will see later there are tricky dimensions in 5 years. 5 years from when? Alright, we will see those tricky dimensions. So that's why this one is first saving this, but the difficulty with soft copy saving is data integrity. What if the file becomes hard disk got corrupted? Okay, or something happened at the cloud server. A blank document is getting downloaded. Right? These difficulties we'll have to traverse. And that's why on all of these grey areas, we just hope that the finance ministry, all of them, they come together and give some guidance. And I hope that the FATF will shout at the government to say, boss, you are not giving guidance to these people on compliance. You created the legal framework. Implementation, yes, you are doing fantastic. But then the issues that we raised way back in 2010 continue to be unaddressed to this day. And therefore, please do something. And I hope the government does something. Right, yeah. Then, now, that was on KYC. After KYC, we need to maintain transaction records. Okay? Maintain the record of all transactions. That is how the section starts. Okay? Maintain a record of all transactions, including information relating to transactions covered under D, in such manner as to enable it to reconstruct individual transactions. This is the purpose of record keeping, so that we can reconstruct the individual transactions which culminated in the money laundering crime. That is something which we should not lose sight of. We are doing all of this to pinpoint finally towards an economic crime. Furnish to the director within such time as may be prescribed information relating to such transactions, whether attempted or executed. We saw this phrase earlier, attempted or executed. What is attempted or executed? He was engaged in negotiations with one for buying an immovable property. It did not go through. It failed. Subsequently, he brought another property close. So I need to keep information of this attempted transaction also. Right? That is again, if you see, attempted or so as we call it in the context of income tax law, there are these charging provisions. Charging provisions state the scope of the law. Now, if we see 12, section 12, this attempted or executed, okay. Now I need to read attempted or executed all transactions. All transactions whether attempted or executed. Okay. Thereafter, maintain a record of documents evidencing identity of its clients and beneficial owners, as well as account files and business correspondence relating to its clients. Okay. Identity of its clients, beneficial owners, we went through during the KYC process. So that's fairly straightforward. Now the thing is, account files and business correspondence also we have to keep. What are account files and business correspondence? Relating to its clients. We will see some nuances here a little later. They shall be kept confidential. So if we just go back a little, one of the concerns which were raised by the Bar Council, the ICA, was client confidentiality. So what the law said, we will enshrine confidentiality in the law. So on paper, confidentiality is maintained. Okay, so they enacted a specific provision, we are done with it. The records referred to in subsection 1A shall be maintained for a period of 5 years from the date of transaction between a client and a reporting entity. Okay, kindly keep this in mind. We'll go through the nuances a little later. Again, thereafter, 1E, which is the third sub-bullet, they shall be kept for a period of 5 years after the business relationship between a client and the reporting entity has ended or the account has been closed, whichever is later. See, all of this makes a lot of sense for ongoing claims. For ongoing claims, live claims, all of this is doable. Okay, you see the difficulty is a little. We see start seeing it now. What is a transaction? A transaction is defined in maintenance of records rules. Okay, it is defined to mean very wide. It is defined very widely. It also includes establishing or creating a legal person or a legal arrangement. If you create a legal arrangement, it is a transaction. Right? So now, the question still remains unanswered. When does a transaction start? When does it end? Okay. Over a phone call, if something happens, or through WhatsApp messages, if things happen, without having emails, letters, etc. When does something start? When does something end? When is it a transaction? Because that is the starting point for KYC. That is the starting point for storing the information on the transactions also. So it becomes important to first fix what is the start point of the transaction. All transactions involving client money are only transactions on which they have earned their fees. Free advice. Chartered accountants, all of us are fairly, at least in the south, all of us are very well versed in this. Free advice. What to do? When does it start? Only free, all advices or free advices also. Would this mean debits and credits in the client bank account or demat account where the RP being a CA had managed? So, if you go back, management of bank savings or securities account. Assume I am managing one bank account. Okay. Now what records should I keep? I will keep records. Okay. Formal engagement letter, everything is there. Every credit or debit I have to keep a parallel record. It will already be reflected in the bank statement of the client. But as a reporting entity, see what's happening? Client's information I am taking and giving it to the government. This is the confidentiality issue which was raised, and this continues, it remains unaddressed. And then that's why, as part of the engagement acceptance, we have to tell them, boss, we will be required to report all of this, so we will be sharing your information with the government. It should form part of the engagement process. Sir?
That time itself client will run.
No, he has no other place to run. Everybody has to do this. Right? The other question which will come is whether he will go to a person who will not put him into all of this trouble in the so-called parallel economy. Right? That is the implication of this. So now, when he is managing bank accounts, the question which comes is every debit credit I should track. Because later on, the law actually says when it gives thresholds, all those risk parameters, we will see all of this. Would this mean collection and payment of monies for the operation and management of the company, say for paying out audit fees of clients' behalf? So I am managing a company. I have to pay audit fees. That audit fees also I should report. I paid water bill. That also should I report? Because they say all transactions where you are managing the client's bank account. If I am paying the telephone bill on his behalf, that also should get reported. And this assumes importance for all of these home family office practices which have picked up in recent days. Many of them are done by private limited companies, some of them are registered with the SEBI. The question comes for those guys, how will this work? Those are the difficulties. Would fundraising services again involved? Yeah, this we dealt with earlier. Again, for all of this, my answer will be yes. Because these things will enable you to reconstruct individual transactions. That is the purpose. The purpose of this entire exercise is to reconstruct individual transactions which finally culminated in that economic crime of, in that offense of money laundering. So that's where all of this will come. Because don't we say that a shell company, so this came in the context of Mauritian shell companies and BVI shell companies, that there are enough debits and credits in the bank account of the company. Therefore, this is an active company, this is not a shell company. These arguments were made to say that they are not shell companies. That's why they are saying, okay, give us all transactions, because only then we will be able to know whether you are actually shell companies or not. The onus is extremely high. Whether attempted or executed, like I mentioned, this is not there in the main provision, but we will have to read it. All attempted or executed, whether attempted or executed. Both transactions we have to track. Okay? That's why there is no guidance on this. And here only an institution like the government can come out with some clarifications and say, okay, these are some case studies, and guide the larger population. Account files and business correspondence. These are those phases. What are account files and business correspondences? We do it through SMS, WhatsApp, Telegram chats. Can this be important account files? Emails, no brainer, they are. Okay, but a lot of things happen through WhatsApp chats. And of late, good practice is to ask the client to formally send an email. Sir, no, don't want WhatsApp chat, you send it by email. That's a good practice of late all of us have developed. Right? But in the context of these cases with an audit firm, with a fairly structured set of work, we can do this. But with unstructured work, what we do? Phonal instructions are given to execute transactions. What to be done? Even that is correspondence. Right? Relating to clients does not mean involving or with the client. So they say correspondence relating to a client. They don't say with the client. So internal organizational discussions about that client will also get covered. I am telling my team member to execute the transaction. Even that will get covered. It is not with the client, but it is relating to the client. Right? Next difficulty is 5 years from the date of the transaction, we have to keep records. How to identify the starting point of the transaction? So like I mentioned, when do we say it has started? With the first email, SMS, WhatsApp chat or Telegram chat where the client introduced himself? At what point in time? Because how I got the introductions also are very important. If we are trying to give a good backdrop of how the money laundering happened, how the client was introduced to me is very important. These are the difficulties. How do you track that? Right? Assume yes, it will apply. How do you track it? Formats are yet to be prescribed. Okay, so for example, for formats for banks and financial institutions and intermediaries on their transactions, the RBI has developed it over time, and there are formats. For this, we just have to hope the formats are helpful and make life easier and not as difficult as the language makes it out to be. Right? When will business relationship end? So there is that other clause, right? 5 years after the business relationship has ended, when will something end? You thought it will end. 2 days later, he called you up again and gave you some work. Right? Then, what if the client stops availing one CA service and without informing him engages another CA and continues with him? You don't know whether he will come back. He is not told you he won't come back to you. You will continue to keep that information. It's as if we have to document our professional lives. Our professional lives we have to document. Right? That's why we just hope that the government comes out with some guidance on this. What is the transaction, say, of immovable property took 5+ years to complete? I've seen that property will be in litigation. That litigation will be never ending. That owner would have gone into IBC. Something like that. The transaction will take a lot of time to conclude. What to do in such case? I'm just taking a simple case of immovable property here. Transition provisions. Okay, so this became effective May. Now, for historical transactions that were not completed as of 3rd May, for transactions commenced as of 3rd May, for whom all should we do KYC? So, one reasonable is live clients today, we will do KYC. Okay. Clients who start from May, we will keep all this information. Ongoing clients, we will do their KYC. But the information, we hope some guidance will come. Okay, typically transition provisions, these are generally addressed in a law or some guidance which comes subsequently. Let's just hope it comes. And then what happens thereafter? The director may call from any reporting entity any of the records referred to in prior sections and any additional information as he considers necessary. They should be furnished to the director within time, and he will also keep it confidential. So, That is the point. Then lastly, enhanced due diligence. These are again new provisions. Okay. So, in addition to keeping transaction records, we should ensure all of these are taken care of. Now, all of these, let's only focus on the red underlines. Take additional steps to examine ownership and financial position, including sources of funds of the client. That is where we will get stuck. Right? Ownership, financial position, to some extent you can get to know from statement of affairs, balance sheet, something we will get to know. Sources of funds. When assessment proceedings themselves happen and the officers initiate 68 to 69D provisions, clients are unwilling to share the source. Forget for KYC or for PMLA compliance. This is what we need to inform them. Act acceptance saying was, world has changed. There is this requirement that has come. If we do immovable property, maintaining your bank account, etc., you have to tell us the source of your funds, without which we cannot provide this service. Okay. Thereafter, take additional steps as may be prescribed to record the purpose behind conducting the specified transaction. Why are you doing this? We have to ask you. We'll ask him, he'll give us an answer. What? How will we move further from that answer? Right? That is where guidance is required. And again, all of these are again, like I said, newly introduced provisions. These will evolve over time. Take additional steps. You don't use such phrases in a law. In law, you have to be specific. Okay, right now they have kept it vague. Hopefully, they will clarify all of this. And the intended nature of the relationship between the transaction parties. I made a payment to somebody. Okay, intended nature of the relationship. You have to ascertain, why are you making this payment? Who is that person? Fortunately, they have not asked us to do the KYC of that person. But then, those are questions at least we should ask, because else we will not be able to answer this requirement in 12AA. Where the client does not fulfill the above, the reporting entity shall not allow the specified transaction to be carried out. It tells boss, you don't undertake the transaction. Okay. Where any specified transaction or a series of specified transactions undertaken by a client is considered suspicious or likely to involve proceeds of claim, the reporting entity shall increase the future monitoring of the business relationship with the client, including greater scrutiny or transaction in such manner as may be prescribed. It doesn't say you terminate the relationship. It says you took greater scrutiny. We need to be careful how to go about implementing this section. The information obtained while applying the above enhanced due diligence measures shall be maintained for a period of 5 years from the date of transaction between a client and the reporting entity. Date of transaction, we go back to square one. Specified transaction means any withdrawal or deposit of cash. Any transaction in foreign exchange exceeding such amount. Any transaction in any high value import or remittances. They have defined the thresholds on all of this, so that's okay. Such other transaction in the interest of revenue where there is a high risk of money laundering or terrorist financing as may be prescribed. For all these transactions we need to do enhanced due diligence. And enhanced due diligence again comes out from that 2010 report which we went through initially. And enhanced due diligence, there is a little guidance in the master direction from the RBI. Although it does not deal with these tricky positions, even for that matter for those banks. Right? So just visualize, if the bank is the reporting entity, forget chartered accountant, if the bank is the reporting entity, what will that poor bank do? Take additional steps. The RBI has not given that guidance today, even till this date. Chartered accountants, forget. Banks itself, there is no guidance on this. It gives absolutely subjective phrases. You should institute risk-based parameters. If payments are happening to designated countries, then you should track them. So they have listed some 20-30 countries, including quite a few of our neighbors. Right? So there is a little bit of subjectivity on this, and let's hope the law evolves. And these provisions would now apply to CSCWAs. Okay? Additional steps to be taken. Banks presently, like I said, they apply those risk-based parameters. This is there in the master direction. Examine ownership and financial position. So that's what the chartered accountant has to do. Nature of ownership. So what should he do? Nature of ownership, country of shareholders, profile of shareholders, source of funding we need to identify. Source of funding we will be able to get. Source, are we supposed to check? What is the source of that source? Are we supposed to ask those questions? Substance, are we supposed to ask questions? There's nobody they have established a malicious company, or they have established a company in say somewhere in the middle of very far away from Bijapur city. Okay, right near the Karnataka Maharashtra border. Let's assume they have established one company. Registered office is there. Okay, are we entitled to ask questions on the substance of that company? Right? Those are the questions which will come. Purpose behind conducting the specified transaction. Concept of motive as per criminal law. Whether it is relevant. It is relevant. Because what we are dealing with is economic crime. Okay. Power to impose fine. So he can impose a fine and all of that. So this fairly is straightforward, nothing much. Yeah. How does he do it? He first issues a warning. Then he directs them to comply with specific instructions. Then finally asks them to send reports, or worst case, he levies a fine. Then fine of not less than 10,000 but may extend to rupees 1 lakh for each failure. What is each failure? He has to list failure 1, 2, 3, 4, 5, 6. Okay. Each failure. Again, what is that failure becomes extremely subjective. Miscellaneous provisions. This is again for furnishing the information. Confidentiality is one part. Then no criminal proceedings or civil proceedings will be initiated. So the law protects sharing the information. So we have to tell the clients saying, boss, look, you give me information and providing you the service, this I will be required to report. Central government may prescribe the procedure for maintaining. So this we will just hope things come. Lastly, this again, what are the records which have to be maintained? Cash transactions, series of cash transactions, integrally connected to each other, which have been individually valued below 10 lakh rupees. So again, a laundry list of transactions are there. We spend a little time on each transaction, we will end up with the same difficulties, similar difficulties which we encountered earlier. Suspicious transactions we have to track, whether or not made by way of cash. I will skip all of this. Finally, what are the due dates? So we have to make these filings online in the FI Fingate website, fingate.gov.in. You have to register and all of that. You have to do it. Suspicious transactions to be reported not later than 7 days on being satisfied that the transaction is suspicious. Within 7 days you have to report. First you have to decide whether that is suspicious transaction. Then within 7 days you have to report. Others, immovable property transactions to be reported every quarter by the 15th of the month succeeding the quarter. Other transactions to be reported every month by 15th of the succeeding month. So here there are bank related transactions, property related transactions, suspicious transactions. 3 categories of all of this. This 5th bullet is a suspicious transaction. Alright. And then last bullet is the immovable property transaction. So these, the due dates are 7 days and quarterly. All the others are monthly. Okay. Online filings to be made on fintech.gov.in. There we have to log in, create an account, what category we are, all of that we will have to do. With that, one important dimension is out of the PMLA amendments are watchwords, diligence and risk management. First we have to be diligent, then we have to manage our risk also. Okay. Diligence, risk management. Professionals to have strong internal governance process for client acceptance and delivery. It's easy for me to put this bullet, but for small and mid-sized practitioners it can be very difficult, because of late we've been seeing economic crimes. They do not happen at a large corporate level. They happen at mid-ranges itself. And that is where this becomes very important. Fee commensurate with services. It looks like not only should we charge them for the work which we do, we should charge them also for the reporting that we are required to do. Only service fees won't help. Service plus compliance fee we should charge, because filing these returns itself is difficult. Say vis-a-vis our tedious returns. Tedious returns is very straightforward compliance. How do we do the compliance for these transactions? Like I said, this is documenting our professional lives. clients to be informed on approach of authorities and evolution of law. At the outset, tell them, boss, this is what you're getting into. Okay. And we need to carefully watch global developments on money laundering. Let's await the FATF review in November 2020, see what it comes out. Fortunately, our government is about 10 to 15 years behind from implementing all of that. But at least we'll be knowing that this is the world we are getting into. Right? Thanks so much. So those are the points which I wanted to share with you. I found this a fairly interesting and challenging topic. I just hope chartered accountants and professionals who are in these specified activities take this in the right spirit. And yes, of course, there are gray areas. But then how do we deal with that? As the IC, for example, I would request the ICA itself to make a representation before the government saying, please clarify all of these things further. So just like we have post-budget memorandums, I think on this we should have a post-notification memorandum. Right. With that, I will conclude. Thank you so much. Any questions, I'll be happy to take.
It's not a fantastic topic to ponder upon. As the speaker said, we should get fees not only for the services charged and even for our compliances. With this, a few announcements. 15th November, next Wednesday, we have a CPE program for Code of Ethics. And 20th November, we have campus placement drive at RCC College, Race Course Road. Hope the topic was very discussed relevantly and everyone has got quite knowledge on this topic. On behalf of members present here and the managing committee members, we would like to hand over a memento to the speaker for gratitude and respect. Participants, the speaker, and for their wonderful participation. Thank you, one and all members. Thank you.